Hello friends, in the series on the income tax cases, today we will discuss a case on the reopening of the assessment of the assessee under section 148, where already the assessment of the assessee has already been completed under section 143 subsection 3 before 4 years, and where the proviso to section 147 is applicable. The issue before the Honorable Bombay High Court in the present case was that whether the reopening of the assessee can be done on the basis of change of opinion, and whether the change of opinion can become the basis for the reason to believe that income has escaped assessment. This issue has been taken up by Honorable Bombay High Court in the case of Sanofi India Ltd versus Deputy Commissioner of Income Tax and others, and this case is reported in 474 ITR at page number 114. The date of the judgment is 29th February 2024. In the present case, the assessment of the assessee was already completed under section 143 subsection 3. There was issue of transfer pricing in the present case. The transfer pricing officer under section 92 CA has determined the transfer price of some transactions, and on the basis of the order of the transfer pricing officer, the assessing officer has completed the assessment. When this assessment was completed, then after 4 years, the notice under section 148 was issued to the assessee on the basis that some material has been imported by some other parties at a different price, and hence the income has escaped assessment in the case of the assessee. There is a proviso to section 147 before 1st April 2021 which says that if the assessment is already completed under section 143 subsection 3 before 4 years, and after that the assessing officer want to make the assessment under section 147, then it is obligatory on the part of the assessing officer to demonstrate that what disclosures the assessee has not made in the original assessment, due to which the assessing officer has to make the reason to believe that the income has escaped assessment. In this link, it is also important to know that whether the assessee was aware of that information at the time of the original assessment, which the assessing officer is going to allege on the assessee that this information the assessee has not disclosed. Or in other words, it is also important that the assessee should know those facts at that time. If the assessee is not knowing those things, then how the assessee would have disclosed this thing to the assessing officer? So in the present case, when the notice under section 148 was issued to the assessee, even without alleging that there is a failure on the part of the assessee to disclose the material facts which were known to the assessee at that time, the objections of the assessee were rejected, and that is why the assessee filed the writ. So when the High Court heard the matter, the court said that once all the necessary facts are before the assessing officer, then the assessee has not to give any further assistance to the assessing officer to take the inferences from that material. The court said that the assessee should be aware of those facts which are not disclosed before it can be said that there is omission on the part of the assessee and failure on his part to disclose them. The court said that the assessee made all the information available to the transfer pricing officer under section 92 CA, and there was not even any allegation that the assessee was aware of the prices at which the third party imported materials. So the reasons do not record how the assessee must have been aware of those facts which the assessing officer is alleging that the assessee has not disclosed. So from the present facts and circumstances, when the assessee has disclosed all the facts at the time of the assessment, so without bringing it on record that there was a failure on the part of the assessee to disclose those facts which were in his knowledge to the assessing officer, the notice under section 148 is not justified. So the court quashed the notice under section 148. At the end of this video, once again I am repeating the name of the case. The name of the case is Sanofi India Ltd versus Deputy Commissioner of Income Tax and others, and this case is reported in 474 ITR at page number 114. Thank you, friends.